And I think we are ready to start. So, ladies and gentlemen, it's my honor to welcome you at today's webinar titled Video Sharing Platforms and the Future of Content Regulation, which is a joint undertaking of the Slovak media regulator and Memo 98, a media monitoring organization which I represent. So under normal circumstances, my colleagues and I are traveling around the world and observing media and elections. But as we do not live in normal times yet, we are at home with our families and we organize webinars with Luboš Kukliš. So this is the fifth one already, and the second one for which our limit of 100 participants has been exceeded. Apart from having a very interesting topic for today's discussion, we also have excellent speakers. So I'm really glad that our invitation to speak at this webinar was accepted by Ms. Kristina Rozgoni of the University of Vienna, Ms. Sabine Frank, the Head of Government Affairs and Public Policy at YouTube, Mr. Ben Wagner of the Vienna University of Economics and Business, Mr. Mark Bunting of Ofcom, Mr. Joan Barata of the Stanford University, and the last but not least, Mr. Luboš Kukliš of the Slovak Council for Broadcasting and Retransmission, who also represents EGA. As you can see, we have people from academia, we have regulators, and we also have a representative of one of the biggest platforms which will be affected by the new AVMS directive. The debate will focus on the new video sharing platforms regulation that was introduced by the latest change of the AVMSD. This is the first time the EU law is addressing the content-related questions of any kind of digital platforms, and many practical issues remain still open. But it is also the future implications for some of the most pressing issues connected to the current regimes of content regulation on platforms, such as transparency and user rights, that are worth examining. I don't know if you know, but the debate has its roots in a blog exchange between Joan and Luboš. So I'm very glad that they are able to continue their discussion today in this virtual environment. And I'm also very glad that they are joined by other relevant speakers, as the implementation period for the directive is coming to an end, and the time for a fruitful exchange on the topic has probably never been better. I will also mention some technical points. So as I mentioned, we have almost 100 people participating. I would like to kindly ask you to use the chat option to pose questions to our speakers. So we will start with Luboš, who will present a few points in a short presentation. Many of you know Luboš, who has worked as the chief executive at the Slovak Council for Broadcasting and Retransmission, and he also chaired ERGA since 2017 until, if I'm not mistaken, 2019. And now he's also chairing ERGA's subgroup on disinformation. So I will give now the floor to Luboš.
Thank you, Rastya, very much, and welcome everyone. Indeed, we had that interesting blog exchange with Joan, and we did that actually twice also live, once in Vienna, once in London, but never publicly. This is our first opportunity to do that. And I'm really glad that we're joined with such esteemed colleagues to help us with it. So we have a lot to talk about. So without further ado, I will try to move on to my presentation. I will try to be brief. It's not an easy topic, of course, but I will try to be as brief as possible and focus on the main points of the video sharing platform regulation. So I will very briefly outline what the Audiovisual Media Service Directive is in its new iteration. Then I will talk about substantial changes to it, and then I will move to video sharing platforms and ask you a question whether this is a new kind of content regulation or not. Now, the AVMSD, firstly, it entered into life in 1989 under the name Directive on Transfrontier Television, or Television Without Frontiers Directive. And it was concerned only with television broadcasting. Then in 2010, its name changed to Audiovisual Media Service Directive. And its scope was enlarged to also audiovisual video on demand, which is, for example, I think Netflix or HBO Go. And then in 2018, this is the last iteration, it was enlarged again to the video sharing platforms. Now, what are the basic principles of the directive? The first one is country of origin principle, which means that every service is based somewhere in the EU, in one of the member states. And it has to follow only the rules of that member state. So the other member states should just accept that once it is legal in one member state, it should be legal in other member states, and there are other licenses and other permits required. And the second principle, or the most important one, is minimum harmonization, which means that every member state has to have the rules that are in the directive. But it is not the only limit, it can go even beyond. So there are member states who can go further with their rules and those that are not doing that. And both of these principles also applies to video sharing platforms regulation. That's why they are also important for our debate today. Now, the AVMSD has different areas of regulation. It is protection of minor, commercial communication, audiovisual works, accessibility of people with disabilities to media, hate speech and media literacy. I won't go into detail, but just to give you a flavor of the things that are touched by the directive. And what are the most substantial changes that the new iteration brings are the co-regulation. It was also, even before in the directive, that many aspects were touched by the co-regulation, or were called upon or were pushed to be co-regulatory. But now it is even stronger, and also in almost every major part of the directive has an underlying push to be co-regulatory. It is also independence of regulators. It was quite strange that when we are talking about independence of the media, there was never any substantial part of the directive dedicated to independence of regulators. Now it is. And I think it is an important move. It may be symbolic because it is hard to actually enforce independence of regulators. Because nominally you can see that a regulator is independent, but in actual life it may not be so, and also vice versa. But at least that the words are there, I think is a great step forward. Now it is ERGA. I am representing ERGA, so I may be a bit biased, but I think the important part of this is that regulators are now connected on the EU level and are being heard institutionally. So ERGA is an advisory body to the Commission, and now spend a lot of time working with the Commission also on the directive itself. Now I think that the actual experience of the regulators is feed into the talks about the future of digital governance, for example, in the DSA debates on Digital Services Act. And then the most important part of the directive, in my view, video sharing platforms. Now, what are video sharing platforms? The definition says that they are those services that provide user-generated content or other programs, but they do not have editorial responsibility of the programs or the content they are serving, but they do organize content. Now, this is not all, because the provision of video, because this is all dedicated to the video on those platforms, the provision of video needs to be either principal purpose of the service, or there has to be a dissociable section for that kind of video serving, or the provision of video should be essential functionality. Now, the most important part, and probably the most controversial one, will be the essential functionality. What is an essential functionality in providing video? And for example, when we were talks and we last year were really dedicated to analyzing this, it is clear with YouTube. If you say YouTube is a service that's providing video and it is its principal purpose, absolutely. But what about Facebook, for example? And the directive calls upon the Commission to clarify this in the guidelines. And a strange thing is that we still don't have those guidelines, although the deadline for implementing the directive, September 2020. Now, the last words we've heard is that we will have those guidelines in July. So fingers crossed that at least before the September, there will be some. But of course, we know many things around it. We know what the Commission officials were saying. So for example, I can tell you that very probably video content on Facebook will be covered by the directive. But just the idea that it's not clear, a few months before the deadline for the implementing directive is not very encouraging. Now, these are the areas in which the video sharing platform will be regulated. So there are rules for the protection of minors. There are rules against hate speech on the platforms. There are rules against criminal offense content on the platforms, and there are rules on commercial communication. Now, we can talk about that later on, but what I would like to really stress are the elements that, in my view, are making this a new kind of content regulation. In the old traditional media world, there was this dichotomy about media and regulation. Media had all the responsibility and all the rights, rights to freedom of speech, right to freedom of media. The regulation was representing the public interest and the ideas of the legislation and so on. But now with the platforms and with the user-generated content, we have a new regulatory player in this area, and it is the active user, the user that is uploading the content. And this is the change that we are moving from the dichotomy to a kind of triangle structure in the regulatory environment. Now, there was a long debate about what the platforms are. Are they media or are they mere intermediaries? Are they either just conveying the content, or are they influencing the content that they are carrying? Now, for video on the platforms, at least this question was answered by the new directive, because it calls them video sharing platforms, and there are rules that are now applied to them. So this is a new kind of entity in the environment. And so this is the triangle. Now it's video sharing platforms, regulator, and user. Now, on the video sharing platform side, what the directive is doing is that it's taking a systemic approach to the regulation. Now, what I mean by that, again, in the old world, you have media that were creating the content, delivering it to the user. A very straightforward kind of situation. Regulator was monitoring the content itself, and the media were responsible for every item of the content that they were carrying. Now, the VSPs, the situations are a bit different. Now, the content is within the platform itself. Now, the user is uploading the content on the platforms. The user is directly governed, or the actions of the user in uploading the content is directly governed by terms of service. And with the directive, it is the terms of service and the rules that are applied to the user, what is regulated, or what is called upon to be regulated by regulators. But it is not every single item of the content itself. Now, the application via terms of service is something that is a bit controversial, and we had this kind of discussion with Johan before. I would just say that in this structure, it is the first line of regulation lies with the platform. So the platform is the regulator, in its own right. So the terms of service were probably included as a mean to carry the regulation towards the user, because the platform is, in the first instance, to be the regulator, and then only that kind of regulation, the application of the measures, is what is controlled in the second order by the regulator. What about user? What are the changes for him? Now, this is the first time that we have a legislation that is from active users creating a kind of regulatory actor. So there are rights and interests of users that are to be taken into account when applying the directive. It is written in the Article 28b, Para 3, and it is clearly saying that those interests and rights are to be balanced against the rights and responsibility of the VSPs and public interest and so on. So this is the first time that we actually have that kind of regard toward active user. Now we also see some of the legislation coming in, and for example, when I was looking at the legislation, or the draft of the legislation from the UK, this is also written there, and I think it is really important that we use the rights and interests of users as a kind of legislative measure that will be really applied during the implementation process. So it was good to see one of the first drafts to have it actually. And the other thing is that it is calling for transparency. It is calling for transparency in two places. It is transparency in complaints mechanisms, and by a very marginal but still interpretative extension, you can also say that it is calling for transparency in content moderation itself. I think this is extremely important because you can probably imagine when legislation was writing down, was being written, it's not that clearly content moderation will be such a important question as it is now. And I think there is a basis to call for transparency in content moderation. So I think it is important to stress that although this is a minor element in the directive, can be enhanced importantly during the implementation process. So just to sum up the position of the user, there's a recognition of an active user in the directive. There is call for transparency of the procedures that are dealing with the user. There is a call for assessment by the measures in the directive by an independent regulator. There's out-of-court redress being written in the procedures. It means that when there's a problem between the platform and the user, there should be a kind of mechanisms that can deal with it before they go to court. Now, important and interesting question is what or how it may look, this out-of-court redress. I think that when it was written in the directive, there was the thing about normal kind of out-of-court mediation, which is a traditional business kind of way to deal with problems. But you can probably also say that it may be, for example, a regulator that will establish that kind of procedure. And this is something, for example, we are seeing now in the draft of German legislation implementing the directive. So they are calling upon the regulator to create that kind of redress mechanism that can deal with the problems between user and the platform. So this may be a really interesting development there. And judicial review, of course, the ultimate level of the problem solving should lie with the judiciary. Now, what about regulator? Oh, apart from the independence that I mentioned already, there is not that much dedicated to regulatory authorities. But I think what stems from the directive now is that there will be new roles for regulators. There will be a role in data transparency, there will be role in cooperation, and there will be greater informational role for the regulator. Now, in data transparency, in order to have any kind of meaningful transparency, regulators will need to be able to gather data, to do audits, and also to do the data verification, that to verify that the data they are getting are actually right, accurate, and so on. Now, with Ben Wagner, we've been talking about this for quite some time, and it is a more problematic just to say like I did now. But it is a question who may be doing the verification. It may not be the regulators themselves, or not every kind of regulator. There may be some kind of centralized way to do this, but it is important to stress that apart from just saying that transparency is important, we need to find a way how to verify data that the public authorities are getting. Now, the cooperation. Well, cooperation will be co-regulatory, of course. I've said that before. Now, it may be a bit tricky what co-regulation means in terms of video sharing platforms, because normally co-regulation have a sub-regulatory side, and the state side or statutory side, the sub-regulatory side is normally an industry-wide initiative. But you don't have any industry-wide initiatives now in the video sharing platforms because there are only so few platforms operating, and it is really hard to now find a common way of them establishing some kind of sub-regulation. But the structure, the systemic structure of the regulation itself, as I just outlined it, is kind of co-regulation in itself. So again, it may be tricky, but I would say that just to distinguish sub-regulation, co-regulation, and statutory regulation will lie in the question who is creating the rules. So if the rules are created by industry, it may be sub-regulation, co-regulation. If it's created by legislation and by state, probably it will be called statutory regulation. Cooperation will be cross-jurisdictional. It is extremely important because these platforms are global, and now we see that most of them, or the major ones, are established in Ireland. So it will very probably be Ireland creating rules for them. So the cooperation of the others will be extremely important to benefit actually from the rules in the directive. And of course, there should be a cooperation in cross-sectoral dimension. It means it's not only media regulators talking to media regulators, but all the other kind of regulation, where we are talking about GDPR, whether we are talking about competition side of things, it will be extremely important. And informational role, the future probably will not be that regulatory for every kind of regulatory authority, but more important will be how they will be able to research their environments, how they will be able to distribute the information that they are gathering in order for the public to benefit from it. And there's a great role in media literacy. We've seen this again in Ireland, for example, that Irish regulators very much engage in this in some very successful campaigns. And I think this is something that regulators should be doing for the future in all other member states. Now, this is all I wanted to say as an introduction. Thank you very much for your attention. I'm looking forward to our discussion.
Excellent. Thank you very much, Lubos, for this introductory presentation, which I think will offer a very, very good opportunity for our discussion. I will now turn to Joan Barata, who is an international expert in freedom of expression, freedom of information, and media regulation. As a scholar, he has spoken and done extensive research in these areas, working and collaborating with various universities, academic centers from Asia to Africa and America, authoring papers, articles, and books. As I have already mentioned, in his free time, Joan writes blogs in which he exchanges views with Lubos. I think there are few areas where, after reading these blogs, where you agree with Lubos, including, for example, the rights of users, which the new AVMSD will bring. But there are also some specific areas where you are more concerned than Lubos. So, Joan, the floor is yours.
Thank you. Thank you very much for this kind of invitation. I must say that, I mean, it's great to be surrounded by so many friends. So it's good to see you all. And I can only hope that next time we meet, we finally can do it in person. The sooner the better. So, I mean, I think that Lubos has already described very well what we're talking about here. I mean, the things that have been incorporated by the new AVMSD, the new provisions incorporated by the new AVMSD affecting video sharing platforms. And what I'll do here is perhaps discuss a little bit the general context where the implementation of the Audiovisual Media Service Directive will take place. The general context where member states will have to operate in the process of incorporating the Audiovisual Media Services Directive into their respective legislation, and also, I mean, the complexity of this process and all the implications and all the elements that are involved in this process. The first thing I need to note is that this is a debate that is quite missed. What I mean to say is that, I mean, if we check, I mean, the usual bloggers, the usual people who use Twitter to talk about these issues, and even the academic papers, there's a lot of discussions. There are a lot of discussions on the implementation of the copyright directive, for example, or the directive, but the AVMSD has been missed quite a lot. I mean, I think that it basically just a few nerds, including myself, and if you allow me to call you this way, Lubos, we've been talking about this, but this is a very, very limited group of people who are worried about this. I think even that the debate during the adoption or regarding the new provisions to be incorporated in the Audiovisual Media Services Directive, when it was debated by the European institutions, was quite weak compared, for example, to the big noise that was made around the copyright directive, for example. Perhaps, I mean, at some point there was some sort of lobbying fatigue caused by I mean, what happened with the copyright directive. But I think that, I mean, the secondary attention that is being paid to the Audiovisual Media Services Service Directive and the way it should be implemented is completely undeserved, because I think that this is a very important piece of legislation that will have an impact, a very important impact on the activities of platforms, of course, because some platforms are very active in the field of video sharing, and will also have an impact on the way regulators perform their activities, and particularly it will increment their responsibility. So I think that we need to talk more about these matters. I would like to say that this is an important and very complex debate, because first of all, here we have a rule. I mean, we have a directive, the Audiovisual Media Services Directive, that basically regulates audiovisual service providers and establishes rules for audiovisual service providers, but also now, this time, has established a series of rules on how to regulate platforms, intermediary platforms, video sharing platforms, considering the fact that video sharing platforms are not audiovisual media service providers. So that is something that we have a sort of a strange body within the Audiovisual Media Service Directive, because here, I mean, the directive is regulating something that is different from audiovisual media service providers. And these providers are, in fact, information society service providers. So basically, in principle, these providers used to be regulated, and are still regulated when it comes to the basic principles, by the e-commerce directive, a directive, an European directive that is almost 20 years old now, and which establishes a series of very basic principles that, besides the provisions included in the Audiovisual Media Services Directive, they are still applicable, these overarching principles that are of particular importance. And in fact, if we read the Audiovisual Media Services Directive, it says that these specific rules need to be applied, need to be understood without prejudice to the basic principles established in the e-commerce directive. And here, I mean, we have a basic principle in Article 14 and Article 15, which is the general liability exemptions applicable to this kind of platforms, unless, I mean, they have knowledge or they are aware of the legality of the content that they distribute, and of course, once they know, once they become aware of the existence of an illegal piece of content, they remove it expeditiously. This is a basic principle, and there's another basic principle, which is that all platforms, all intermediaries, including video sharing platforms, cannot be subjected to general obligations of monitoring content. And these are two principles that are still applicable, and of course they need to be incorporated into the debate on how to interpret and how to enforce Article 28B of the Audiovisual Media Service Directive. But to make things more complicated, now we have a process of revision of the e-commerce directive. And obviously, these will have an impact on the way video sharing platforms will be regulated, and even may have an impact on the Audiovisual Media Services Directive itself. You know, well, most of you probably know that there are already some reports made by different committees at the European Parliament on this matter. There's an open consultation now ongoing until September on the future Digital Services Act, which is supposed to replace the e-commerce directive. And of course, one of the things that is on the table is whether, I mean, these basic principles established in Article 14 and Article 15 of the e-commerce directive will be changed or not. I think that the majority of stakeholders, they support the idea that these liability exemption clauses need to be kept, and the idea of a liability exemption and the Good Samaritan clause, the so-called Good Samaritan clause, need to be kept. But this is an ongoing debate that, as I said, will affect, I mean, video sharing platforms and the way they are regulated. This debate is also taking place in parallel in the United States, and I think that it's important to note this because there are always, I mean, there might be interactions, let's say, between the two debates. There's an ongoing debate on whether Section 230, which is the equivalent of Article 14 and 15, even if it doesn't say exactly the same, but Section 230 of the Communications Decency Act in the United States, on whether it has to be changed the way it is now. We also have in place now or an ongoing debate in Europe about the future regulation on tackling terrorist content online. These will also have an impact in this debate because, as Lubos has mentioned, I mean, one of the areas where regulators can impose certain duties of care when it comes to video sharing platforms is criminal offenses, and particularly terrorism. So the way terrorism is defined, the way powers of public administrations vis-a-vis online platforms are defined by this regulation, this specific regulation that is, of course, very controversial, and it has triggered many different opposite positions on these, and there are still, I mean, the trilogue is going on, and I think that still there are many things to be seen there in that context. But this will also have an impact in the process of implementing, or at least in the process of enforcing at the national level the new rules regarding video sharing platforms as established by Audiovisual Media Services Directive. I would also say that in this context, I mean, there's another element of complexity, another factor of complexity, which is the crisis of the principle of country of origin. We know that this is a principle that, for example, is established in the context of the Audiovisual Media Services Directive since, its original, starting from its original version. But the truth is that when it comes to platform regulations, states don't seem to give much importance to this idea of country of origin. Because, for example, if we look at Germany, well, the NetzDG is basically in contradiction, might be seen as something in contradiction with the idea of country of origin, at least when it comes to the regulation of information society services, because in principle, I mean, the German legislator wants to impose, I mean, restrictions, obligations to platforms that, well, are present in Germany, but they are not they are not established in Germany, for example. So I think that this is an important debate. And I would also say that platforms tend to keep some distance, platforms themselves tend to keep some distance from the country of origin principle, because, I mean, they keep saying, and there are strong reasons to do so, that they respect national legislation. So they have never used in Europe the idea of country of origin, for example, to deny or to reject the competence of the German authorities, for example, with regards to the content that they host. They don't say, I mean, you go to Ireland, but don't bother us here in Germany. No, they accept, I mean, the competence of national authorities. So we see that the country of origin principle, which makes sense in the context of traditional audiovisual media services, I mean, now is in a sort of crisis, and we have heard, I think we all have heard that in the context of the new DSA, I mean, this is something that might be changed. Well, it's not sure, it's not clear what's the alternative, but this is something that might be changed. Another element, and I think it is very important, is that very recently, just a few days ago, the French Constitutional Council has established a series of limits of what public authorities and what platforms can do when dealing with illegal content. When it comes to public authorities, the French Constitutional Council said, well, it's not constitutional that an administrative authority imposes on a platform the obligation to take down a piece of content in 1 hour without giving that platform the opportunity to ask for judicial review. That is disproportionate, and that is not acceptable from a constitutional point of view. That is very important because it challenges the way the regulation, the proposed regulation on terrorist content online is designed. So this is, I think, something that deserves some discussion and some reflection. The second thing is that the French Constitutional Council also said that it is not constitutional that an authority imposes, or let's say that the law imposes on a private platform the obligation to review and take a decision on the legality of a certain piece of content in a time frame of, let's say, for example, 24 hours. What the French Constitutional Council says, well, this is too complicated. You cannot ask a private platform to take such a sensitive decision vis-a-vis the exercise of a fundamental right in the time frame of 24 hours. And I would add that not only from a constitutional point of view, but even from an economic point of view, I mean, imposing such an obligation would represent that only the most resourceful platforms can survive in this context, but because only them have the power and the capacity to hire the team to take this decision. So in this context, now what we have is, of course, I mean, the need to apply the principle of country of origin, which means that the Irish regulator, as Lubo said, will be in principle in charge of this, and the Irish legislator will also be in charge of establishing the basic set of rules. Because of the elections in Ireland, we still don't know what's going to happen. It seems that that in Ireland, which is the most important country for what, because of what I've just said, I mean, the transposition will not take place in time, but we are all waiting to see what's happening in Ireland. But let me just, I mean, put an example of how complex this can be. What if the Irish legislator, on the basis of the Audiovisual Media Service Directive, says this piece of content should stay up because we understand that this is not hate speech, but then, and let's imagine that this is a piece of content that has been published by a German user, and then on the basis of the NetzDG, there's a German authority, or there's a German regulation that is putting pressure on a platform to do exactly the opposite. What's going to happen? Because here we may see an overlap of different legislations and different ways of understanding the responsibility of platforms depending on the kind of provisions that you apply. And I'm sure there will be some examples that may come up. And here we are not talking only about the necessity to coordinate the Irish regulators with the German regulator. Here we're talking about decisions that can be taken by a German judge who doesn't care about what an Irish regulator may say, even if we say that the Irish regulator is the competent authority to take the decision on a certain piece of content that is that may be hate speech. So I believe that we will see many challenges here. And to finish, last but not least, I mean, if all this was not enough, now we have COVID. That creates, I mean, the perfect storm. I mean, in the middle of all these things that I just described, which is already a nightmare for lawyers and regulators, we have COVID-19. And with COVID-19, I mean, I've heard all sorts of arguments. One, I mean, some people saying, okay, you see here, I mean, platforms have been able to do the right thing, so we need to introduce regulations in order for platforms to keep doing what they have been doing during the crisis, because they have been really responsible. But other people saying, no, well, I mean, this shows that, for example, filtering is a disaster because many mistakes have been done because, I mean, platforms have basically relied on algorithms rather than on let's say, human moderation for obvious reasons. So this COVID scene has only, I mean, increased the intensity of these debates and, I mean, the way things need to be done. Also, the debate about filtering, whether filtering is good or bad, I think that now it is more intense than ever. So the only thing that I can say here is that, well, I mean, I tried to present what needs to be taken into account, I think, the complexity of the situation and the challenging task that we have ahead. We can only hope that at the level of the EU institutions, all these, I mean, legislation that now is under discussion is finally adopted, that all the things, all the different pieces of the puzzle are taken into account in order to avoid contradictions, and that finally we have a clear framework that is, useful to protect the rights of users and also to make sure that everybody knows, the role that it needs to play in this difficult context. So thank you once again.
Thank you very much, Joan, for this very detailed description of the challenges that will be basically there. In introducing this directive, and particularly, in relation to the country of origin principle, and the examples that you gave. I think this is really very. It only shows that it's such a complex issue. So I will now turn to Christina. The first time we met was in Kyrgyzstan, where we both work for the Venice Commission of the Council of Europe. She's an assistant professor with the Media Governance and Media Industries Research Lab at the Department of Communication of the University of Vienna. In her research, Christina focuses on media governance, including on the representation of public interests, of democratic values and fundamental rights within the complex of and highly technocratized policy and regulatory processes. So I'm very glad that you accepted the invitation today, and I would like to kindly ask you to elaborate a bit on the future of regulation. The floor is yours.
Thank you, Rasto. And as Joan already mentioned, this chaos, which is a nightmare for many lawyers, looks a little bit like our travel challenges when we first met, I think. And that was also pretty chaotic, but at the end it was very nice. And right now we are here, and so thank you for the opportunity for inviting me. I will briefly try to reflect on one particular aspect Lubos put forward in his presentation, the aspect of the regulators, and the aspect of the regulators in the European, especially in the European Union's context, and the role of regulators within this chaos and regulating the chaos. So in my view, the AVMSD is the first ever legislation based on which the normative grounds of online content regulation across Europe, at least European Union, could be built up. I see this process as an opportunity because I'm an optimist. I see an opportunity for providing the foundations for meaningful public scrutiny and find a place for independent and good regulation of intermediary platforms. If we consider similar antecedents, maybe competing antecedents, like the German Netzwerkdurchsetzungsgesetz, as Joan also mentioned, which is competing with the AVMSD on several grounds. The German case and the role of the Federal Office of Justice in Germany, so the Bundesjustizamt, overseeing the law, is very different than the role that is provided by the AVMSD to the regulators over content. In the German case, what happens is that basically the Bundesjustizamt inspects the transparency reports published by the platforms about takedowns, not takedowns, procedural matters, organizational matters, but there is no inspection in terms of merit of the self-regulation or solo regulation, if you would put it this way. So basically there is no regulatory oversight provided by the German Federal Office of Justice about what is exactly happening with regards that those content that is taken down or not taken down by the platforms. Even the €2 million fine that was issued last summer against Facebook was based on procedural grounds that Facebook was using a very shady, let's put it this way, manner to channel users' complaints into non-regulated or unregulated areas, and the fine was a result of these procedural matters. Also, if we take another kind of similar precedent, maybe the French case, which also Joan touched upon at least indirectly. So the higher audiovisual court of France, the CSA, was entitled for a certain type of content regulation with regards to disinformation, but actually also this role of the French regulator was far more limited than the potential role that the AVMSD is entitling the European regulators right now. And actually, it was not really tested. And as we've heard from Joan, it's already under constitutional, legal constitutional review right now within France. So all in all, in my view, the AVMSD's implementation will be the first moment to embed national regulators in audiovisual media content regulation and test the functioning thereof. As I said in the beginning, I am an optimist, but I'm not naive, because this momentum has a lot of buts and ifs. So first, let me also touch upon this issue of the country of origin principle and the problems of the country of origin principle. So one of the results of applying the country of origin principle is basically putting the Irish regulator, the Broadcasting Authority of Ireland, into a central position, regulating for Europe, if you wish not, you would like to see it this way. So basically, to put in place rules on hate speech, on content that is harmful to minors, on YouTube, for another 26 European Union member states. And what is the problem with this? The problem is that, again, similar antecedents for example, in the area, in the territory of data protection, has to warn us and has to alert us about the responsibility of a certain regulator regulating for Europe. And here I'm quoting an open letter that was published on the 25th of May, basically a few weeks ago, and was addressed to the European data protection authorities, the European Commission and the European Parliament, complaining about the mishandling of data protection rules and regulations by the Irish Data Protection Commission, which is empowered by the GDPR, the European Data Protection Regulation, to regulate for Europe over the most important online platforms, including Facebook, including Instagram, and including WhatsApp. This open letter claims that 2 years ago, when in the moment when GDPR entered into force, high-profile cases, 3 high-profile cases against these platforms were filed, and since then, absolutely nothing has happened with these cases. Fundamental rights were not enforced for more than 2 years. This is a quote from this open letter. Also, another 7,200 complaints were filed with the Irish regulator. Again, nothing happened, not even a single fine was issued under the GDPR. And this open letter claimed that in case of data protection, the GDPR was as strong as the weakest regulator. So the reason I have brought this maybe parallel example here is to point out what potential consequences of the country of origin principle in terms of responsibility of a certain regulator will play out. Maybe later we could go also into more details if we focus on content. For example, what is going to be a loss because of the country of origin principle. Right now I'm working on a comparative research looking into the differences of hate speech regulation only in audiovisual media regulation, and what is going to be at loss if only the Irish regulation is going to be applied across Europe. Also, focusing on the regulators aspect, and again, here is something that, that my optimistic view should not overview, is the very often daunting reality of national regulators across Europe. And I know that you, Lubos, also in your role as representing ERGA or the Slovak regulator, you should not be very critical about your colleagues, but I could be, and I should be. So I'm just referring here to, for example, the 2019 report of the European Audiovisual Observatory about the non-independence and about the bad regulatory practices of European regulators being old-fashioned, non-independent, often captured by politics, economic issues. And these are the players who are supposed to live up to the challenge of next generation regulation. And here I'm already referring to Mark and his involvement, for example, on laying out the foundations of an anticipatory regulatory model, beautiful concepts, beautiful ideas, and daunting realities. So I think this is also something we have to be aware about and talk about the responsibility here. And here again, and this is also something for you, Mark, maybe later on you can catch up on this. We in Europe are crying over the loss of the ever best regulator within Europe because Ofcom is not ever with us. And we have very few good ones like the Slovak one, and this is also something I could say here. All in all, I think the role of the regulators is again, I see hypothetically, theoretically, as a great opportunity for first time ever meaningful public scrutiny. But here again, a huge responsibility of certain regulators, but also of the European community. And here I'm referring to ERGA, also to the Commission. Overseeing what is going to happen is, I think, crucial for future debates. More later. Thank you.
Great. Thanks so much, Christina. I actually share your optimism, but I also agree with you that there are still many questions and many buts and ifs, as you put it. Initially, I was planning to open up now for questions, but we have still 3 speakers that are going to speak, and also we have also the Irish regulator representatives. So I would like to also ask them later on if they have any points, since they have been mentioned so many times already. So maybe I will ask Joan to look at the chat. There are, apart from very nice messages to your presentations, there are also a couple of questions. And in the meantime, let's move on. And you, Christina, mentioned Ofcom, and we are exceptionally happy and lucky that we have Ofcom represented here at this webinar. And so I'm going to give floor to Mark Bunting, who is leading policy work and supporting Ofcom's content policy team to deliver media and broadcasting policies that promote quality and choice for UK consumers. Mark is managing senior stakeholder relationships, representing Ofcom's externally, and is a member of Ofcom's senior leadership group. He has also advised companies, government, and regulators on media and technology policy, and worked as the head of strategy at the BBC. So, Mark, I hope that there will not be any problems with your with your voice because there were some small technical issues, but I hope that it will be all fine. The floor is yours.
Thank you very much, and do let me know if I'm not coming through clearly or there's a delay. And thanks everybody for a fascinating discussion, and for Christina for her very kind words about Ofcom. I thought I would start by saying a little bit about the UK's process around AVMS implementation, which is itself a slight oddity, given that we're no longer a member state of the EU. Nonetheless, the obligation to transpose the directive is an existing legal obligation, and the government intends to do so. We're expecting the transposition to go ahead in the autumn. I'm not sure we'll quite hit the deadline of the 20th of September, but I don't think the UK will be far behind that date. And that's the point at which the regulations will be in force and Ofcom will have new powers in this space. It's probably worth saying at the outset that for the UK, AVMSD, at least with respect to video sharing platforms, is seen very much as a staging post to the wider online harms regime that the government is intending to bring in. That is going to take a little while longer. We don't have a precise timetable for that legislation as yet, and therefore the VSP regulation will be introduced first. As Lubos said earlier, of course, much remains unclear. We're still waiting for Commission guidance. The UK statutory instrument that transposes the directive is unlikely to be published till September. And although Ofcom has known since February that it was confirmed as the regulator for video sharing platforms, we've not yet issued our own guidance. Of course, we won't do that until we've seen the Commission guidance. So the immediate next step for us, once the legislation has passed, is to work with UK-based video sharing platforms to help them understand their new obligations and how to come into compliance, and in turn to inform the development of our guidance. We intend to continue to work with regulators across the EU to understand the various approaches to VSP regulation, and where we can work collaboratively to develop and align our regulatory approaches. We will be empowered to take robust enforcement action against willing non-compliance from services or following serious instances of egregious or illegal harm. But I think it's probably fair to say that ahead of issuing our own guidance for UK VSPs, we will do this in a flexible way, recognising that VSPs themselves have had relatively little time to respond to the guidance, both from us and from the Commission. I thought the most useful thing I could do is just talk a little bit about the principles that underpin our regulatory approach to this area, which we have been doing a great deal of thinking about, both in the context of transposition of AVMS, but also, of course, our potential role in online harms regulation under the government's new regime, albeit the government has only said at this stage that it's minded to designate Ofcom as the regulator for online harms, and therefore we don't know yet whether that will be a task that falls to us. Nonetheless, we've been thinking about the principles that underpin our approach, and I think I would usefully describe 4 principles today. The first principle would be to focus on what works. The directive, of course, specifies measures available to VSPs, but it's not prescriptive about any particular approach. In the first instance, it's for companies to decide the most effective response to the harms on their platforms. We see a role for Ofcom in providing robust evidence, both of the nature and prevalence of harmful and illegal content, and of the effectiveness of different responses to it. And of course, the measures available to VSPs in the directive are wide-ranging, not at all just about content blocking or notice and takedown. Media literacy, a focus on critical understanding, user empowerment, parental controls and rating systems may be equally valid responses, depending, of course, on the nature of the content and the harm it may cause. Now, in saying that we intend to focus on what works, it's important to recognise, I think, the complexity that some of the other speakers have referred to. The challenge of managing online illegality is far from straightforward. We recognise the complexity of doing that. So I don't want to sound too glib about the challenges associated with doing that. But as a founding principle, the idea that our assessment of the adequacy of VSP's measures should be based on an assessment of their effectiveness is going to be core to our regulatory approach. And related to that, the second principle is that regulation will involve us taking a holistic approach to companies' protective processes and not focusing primarily on their response to individual content decisions. In fact, the UK's view has been that it's not practical or appropriate for the regulator to consider individual complaints about content on VSPs in the way that we do for broadcasting. Instead, UK-based VSPs will be expected to provide an effective complaints function and an independent appeals process. Of course, Ofcom's experience in complaint handling will be reflected in our guidance to companies, but the implication of this approach is that there won't be a one-size-fits-all solution to user redress. Companies, we think, need flexibility to meet their obligations in a proportionate way, and will be particularly sensitive to the potential regulatory burden on smaller firms and any unintended impact on competition. The third principle is that we see the regulator's role as primarily about the promotion of accountability. That means ensuring that companies have carried out an adequate assessment of harm, developed and implemented appropriate responses, established means of measuring the effectiveness of those responses, and reviewing their policies accordingly. Of course, we'll engage closely with VSPs to ensure they understand their obligations, and we'll have the information gathering powers that we need to ensure that we can assess their responses effectively. Of course, to some extent, this is familiar turf to Ofcom, which already has teams with specialist monitoring expertise, for example, in our regulation of the BBC or regulation of BT. But we also recognise that the challenge will be significantly different in this area, and we are developing our technical capability and understanding of platform architectures to help us ensure that we can ask the right questions. The final principle is that we intend to focus on outcomes for users. We will put in place a comprehensive programme of research and market intelligence, as well as collecting data from platforms. In other sectors that Ofcom regulates, for example, home broadband or pay TV complaints, we've developed tools that provide information to consumers to support informed choice, and we'll consider opportunities to do something similar here. And alongside a focus on user protection, we'll provide guidance for regulated services to safeguard freedom of expression and advise them on how to put in place tools to monitor for inadvertent overblocking of legal and non-harmful content. So we envisage a very collaborative process, of course, where we see evidence that platforms' processes are inadequate and that they fail to do something about that, or that they refuse to provide the information that we need to assess outcomes for users. We'll be robust in our enforcement, just as we are in the other sectors that we regulate. But we recognise that the primary responsibility for managing the risk of illegal content has to sit with platforms themselves. I suppose the final point I wanted to make is that we recognise as we embark on this regulation, and I agree with other speakers that it is novel and is a significant shift in our regulatory approach, we recognise that Ofcom can't be the centre of all expertise on the complex issues raised by BSP regulation and the AVMS requirements. So working with partners is going to be central to building our capability. We're already talking to specialists and to research institutes such as the Alan Turing Institute to inform our policy thinking and regulatory approach. We're going to be issuing a formal call for evidence, hopefully before the summer break, and that will launch a new phase of engagement for us in which we'll seek views from industry, civil society organisations, experts and users on good practice by VSPs in managing harmful and illegal content. And we'll also look to gather evidence from VSPs, obviously primarily the services in UK jurisdiction, but we think it's also an opportunity to gather more information from some of the bigger platforms that may come into our scope in the online harms regime. And we'll be gathering more data about their processes and about the ways in which they evaluate the impact and effectiveness of safety tools. Later in the year, once we've reflected on that evidence, we'll consult on guidance for VSPs, which will represent the first advice to industry that we've provided on protective systems and processes. I very much hope that we will be able to benefit from the expertise in this virtual room in that process. We welcome submissions and views and opinions, and of course are very enthusiastic to continue this dialogue. Thank you.
Excellent. Thank you so much, Mark, for your time and also your expertise. I think this is always very beneficial for us, I mean, to hear the Ofcom's experience. I will now turn to Sabine Frank, who is the head of Government Affairs and Public Policy at YouTube. So far we have heard from regulators, researchers, but I'm really glad that we have the opportunity to also hear from the biggest platform that will be affected by this directive. So obviously I understand that it's yet too early to talk about the very practical implications of how you will be affected by the AFMSD, but still, what are your thoughts at this stage, and how do you see it in coming? So the floor is yours.
Thank you, Rasta, and thank you, everyone. It was already like a very interesting morning for me, so very good to be here, and thank you for having me and inviting me. So we welcome the process towards implementing the updated AVMS directive, and it's good to speak with this group about next steps and ideas. It's very important to iterate that the text recognizes the key differences between traditional broadcasters and video sharing platforms such as YouTube. I'm not sure if we will actually be the largest one being affected by this law, so we will see how this plays out. As member states move with transposition, the country of origin principle and the need for harmonization cannot be overstated. And we have heard this also from other speakers. And John mentioned NetzDG as one example and commented that we as YouTube did not state that this is like NetzDG is a violation of the country of origin principle. I actually have to say the contrary is true. So we stated that very clearly, both vis-a-vis the European Commission as well as the German government. Just last week, I had the pleasure to be part of a public hearing in the German government and also made this point. So what we actually do is we implement NetzDG on a voluntary basis where we clearly see also the legal problems. And another also German example is the Interstate Media Treaty, where the Commission was very clear in its statements towards the federal states of Germany that they see a violation of the country of origin principle also in the Intermediate State Treaty. So this is why I think it's so important to have that principle very clearly enshrined and also have the respect by member states. That is extremely important to us, and as well as mentioned also by other speakers. So coming back to AVMS and the role of video sharing platforms. So for one, the role should be to take appropriate measures to protect users and particularly minors from harmful content and audiovisual commercial communication. And as second, to provide tools to users who upload videos to promptly with their own obligation. So particularly when they themselves constitute to be a media service provider. These tools, I'm sure we will speak about this later, but for example, content rating tools or product placement disclosures should be applied uniformly across borders so that European users are protected equally. Because after all, users consume content from different countries and different languages, not just in their home country. So while our attention is on AVMSD, it's important to recognize that we have not waited for the legislation or regulation to do the right thing. So we have been addressing problematic content online. We've made very significant investments to better detect and address problematic content, and to do this responsibly, and I think in our case at scale. Open platforms such as YouTube are a benefit for a thriving audiovisual sector. So YouTube enables people to share their talents across the world. And I think it's especially important, being here in Europe, to state that over half of the watch time from EU-based content creators actually comes from outside the EU. So when platforms foster openness and operate at this scale, there obviously is a risk of potential harmful information that might occur. So we do recognize this, and we recognize that we are responsible here, and we need to have a comprehensive approach and appropriate systems in place to adequately deal with this type of content. As most of you on the call and who listen to this are well aware that we have developed robust community guidelines, which are a set of rules that define what is allowed and not allowed on the platform. These policies include prohibition on hate speech, incitement to violence, terrorist recruitment videos, and child endangerment, and they do evolve constantly. So just during the Corona crisis, I think this is a very good example to showcase this. We have updated our global policies related to coronavirus to better meet the challenges we are seeing on YouTube. YouTube has clear policies prohibiting videos that promote medical unsubstantiated methods, including those that claim to prevent the coronavirus in place of seeking medical treatment. These policies apply, by the way, to all types of content, so both videos and comments. And we have developed a comprehensive approach to tackling controversial content on our platform. So this approach is fourfold. We remove content that violates against our policies, and I should add also that violate against local law. So we raise up authoritative voices when people are looking for breaking news, for example, that reduce the spread of content that brushes right against our policies. And we see actually, we have set a higher bar for channels that can make money out of our site. So rewarding is only for trusted, eligible creators and not for everyone. YouTube removal process operates at a high scale, as I've mentioned before. We remove content globally, and just in the last quarter of last year, we have removed 5.8 million videos and 500 million comments. And I can tell you that a bit later today, we will release our Q1 transparency report. And I can also tell you that those numbers I just mentioned have even gone up slightly. So in 90% of the cases, machines have flagged content to us and not humans, which is especially great because that allows us that more than 50% of the videos were taken down before they have been watched altogether. So I think this speaks for the combination of machine and humans. The online ecosystem is an incredible dynamic environment, and we need to make sure we remain flexible in our approach. We need both the technology and the teams to be able to adapt quickly to new threats and to make sure we understand the nuances of the content. As such, regulatory oversight of content sharing platforms must be guided by 4 principles. Governments should clearly set out the rules of what constitutes permissible content. Oversight should set out the standards for transparency and best practice. Oversight should address systematic failures to respond to identified violations. Governments should foster international cooperation while recognizing appropriate national differences. Let me now just focus very quickly on two, in my view, key points in this whole discussions. The first one is the set out of standards for transparency and best practices. Our work is actually, our policies actually work best when users are aware and understand the rules of how we enforce them. And this is why we work to make this information clear and easily accessible and available to all. So transparency also provides a starting point for a good political discussion and practical discussion about effective practices, and is a basis for informed discussion. We have developed a lot of help center articles and recently launched a new resource explaining how YouTube works in very great detail. As I mentioned before, the transparency reports launch regularly every quarter. The new one will go live later today. But we need governments to take a flexible approach. Overly restricted requirements, for example, on one size fits all monitoring obligation or disproportionate penalties would reduce access to legitimate information. It is crucial that the right balance is struck here and will be struck in the future. The second point is the systematic failure to respond to violation and not one-offs. So oversight should focus on ensuring procedural accountability, addressing systematic failures rather than individual one-offs. Where clear evidence indicates that the platform is systematically failing to follow through on their stated commitments, and enforcement bodies could and should be empowered to conduct a review. But at the same time, and the same way that other companies can launch jurisdictional overview over a regulator's decision, video sharing platforms should also be able to bring evidence before a neutral arbiter to contest findings of systematic failure and raise countervailing considerations. That could be respect for international human rights. So while a great deal of my talk actually focus on how we see regulation oversight, it is important to highlight that there are a number of outstanding issues where the Commission and ERGA should look into, give future clarifications of the directive, whether it be ground for user ratings or program versus user-generated content, and age gating requirements. So we would be very keen to continue this conversation and doing this already during this great event. So thank you very much for your time and listening, and looking forward to the discussions.
Thank you very much, Sabine. And obviously, I'm also mindful of time. We have about 11 more minutes before we finish, but obviously we still want to give the floor to Mr. Ben Wagner, who is an assistant professor and director of the Privacy and Sustainable Computing Lab at Vienna University of Economics and Business, where he focuses on technology policy, human rights, and accountable information systems. So we volunteered to be the last speaker. We have had very interesting presentations. So now I will ask you to take the floor and present your views.
Thank you very much. I'll do my best to keep it brief, also so that we can maybe fit in at least a question or two from the audience, because I think it would also be very interesting to hear their perspectives as well. So I'd like to say that I am very encouraged by this debate, because it seems that we are starting to debate issues that for maybe the last decade have previously been negotiated in an extremely informal context. And I think this is important. Because where previously, for example, there was let's say a conversation in between regulators and platforms about what types of content should or should not be on these platforms, and certain types of pressure was exerted in one place and different types of pressure was exerted in the other place. We now can do this in a more public forum, and also then start having a conversation about what is possible and what is reasonable for an independent arbiter to be able to have this conversation, where the boundaries of this are more clearly defined. And I think should be the main central element of this conversation, that when we're talking about the future AVMS implementations, that we significantly and systematically consider how existing processes can be institutionalized, Of course, in a flexible way, I see no issue with that, but certainly institutionalized in a way that they are transparent. So it shouldn't be necessary or possible that platforms simply claim we are following some laws but not others because we don't agree with those laws. There should be clear standards, procedures, and mechanisms to ensure that if they choose not to follow certain laws, or that they choose to respond to certain legal requests differently, that there is a process and a mechanism behind that to show why they're doing so and to justify the process or in which this happens. And this goes to a wider challenge, which I think we see throughout the AVMS, which is a response to an ongoing failure, less in the video sharing platform world and more in the world of online content moderation, which is what has been discussed quite frequently now, the lack of common standards, the lack of common frameworks, the lack of comparability. Right now, we've heard that YouTube will be releasing their transparency report this afternoon. It's almost impossible to compare this transparency report even to other Google transparency reports, let alone to transparency reports in the Network Enforcement Act that are provided by Google, let alone to those of other companies. So we're in a situation where we have transparency reports by huge amounts of actors that are very relevant and important for users, but are completely incomparable because they start with a different basis, a different set of meanings, and a different set of logics. And if you look at the fines that have been given to Facebook now in the German context, where they were essentially recategorizing different types of content based on what they thought was appropriate as either illegal content or as terms of service violations, we see the very challenging nature of these incomparable transparency requirements. Now, what I would also add is that there is an incredible scope here to go beyond individual pieces of content, which is mostly where the debate in transparency reports is focused on, and actually have a more structural consideration about the automated systems. We heard already from YouTube now that 90% of the cases they flag is based on machines and not based on human flagging itself. And many of the platforms that we've had conversations with in our research lab also share similar travel of direction, which increasingly focuses on automated takedown. Yet the mechanisms we talk about and the way we discuss these issues is very much focused on individual case-by-case basis, rather than saying we need not just a comparison of individual cases, but a structural comparison of automated systems. So if you will, a comparable algorithmic auditing framework that allows for a comparable systematic ability to say this platform is focusing on these factors, this platform is focusing on these factors. And this is important because many of the aspects of these automated systems may pose considerable challenges, both for freedom of expression, also regards to discrimination and other very important aspects of international human rights. So if we're talking, for example, that the variable included in some of these automated systems is gender or is related to skin color, even if this is not immediately obvious, it may be highly relevant for the way in which content is taken down. And especially in the context where we see demonstrations across the world against police brutality and also against the discrimination of individuals, we shouldn't forget that there's not just a corona crisis going on, but also a crisis of governance in how human beings are governed on an everyday basis in a discriminatory manner. And this discriminatory manner extends itself not just to human and organizational institutional systems, but also towards technical systems. So we need to be very aware that even well-intentioned systems can very quickly spiral down in a direction which will lead to automated discrimination and automated processing of content in a way that will lead to certain types of voices being heard and others not being heard. Now, this is not to say that any individual company would necessarily be good or bad at this. It's rather to say that right now, we just don't know. We don't have enough transparency. And based on this transparency, we don't have enough accountability to make meaningful statements which would have meaningful consequences for those organizations. So I think there's a great deal of work to be done. And perhaps the last thing, this is part of ongoing work that I've been doing with Luboš and some other colleagues as well, to try and really understand what is going on in this industry. We don't have a type of transparency reporting under the AVMS or under any other legal instrument at present that would provide for verified transparency data. Now think about that for a moment. We have to, in situations where we are responding to serious challenges for the whole of society, whether it's related to disinformation, whether it's related to content being provided to minors and many other contexts, we have to rely on platforms being honest and telling the truth. We're essentially relying on their data without any verification mechanism or independent oversight of that, with very few exceptions. So, for example, in the case of the Network Enforcement Act, Facebook were fined for providing what was clearly considered to be not the correct data under the Act. But that doesn't mean that they were required in future versions of the data they provided to have an auditor ensure that this data is accurate. Now, data is becoming so important in these areas that to accept unverified data as the basis for a public conversation seems to me to be quite an irresponsible approach to this. We need to acknowledge that verification of this data is a minimum requirement to have a meaningful public conversation about what is going on in the area of content moderation. And I just imagine for a second if you were thinking about the area of financial services. If we were to accept the public records of a publicly traded company that had not previously been verified by an auditor, that itself would be highly problematic. So if we're going to take this public importance of these issues and aspects, we need to have a conversation about how we can ensure that the data is verified, that the foundations of our conversation are comparable, and that we're able to start talking not just about what is out there, but how we can compare the approaches of different providers, both on the basis of individual cases and on a more structural basis. I hope that provides just enough time for a few questions as well. Thank you very much.
Great, thank you so much. And let me also clarify, I didn't mean that we had only 11 minutes for the whole webinar. Obviously, we will go until 12:30 and possibly even a little bit further, just to make sure that we have enough time for questions and answers. So with this, we, in a way, finalized the first part, which was to hear from the speakers, but I still wanted to take the opportunity that we have the representatives of the Broadcasting Authority of Ireland, as you have been mentioned several times. So I would like to ask Ms. Craig if she wants to make some points after we heard from the speakers.
Hello, can you hear me?
Yes, we can hear you.
Thank you. Thank you, and thank you to all the speakers. It's been a very interesting morning and some very, sorry, just let me start my video here. Yeah, sorry. That's it. Okay, I think you have my video now too. Thank you, and thanks to all the speakers. Lots of interesting points being made here this morning. And perhaps I could just, if I could just take a couple of minutes. What I'll try to do is perhaps at a high level, perhaps not respond to all of the individual comments that have been made, but perhaps take the time just to outline some approaches that we in the Irish BAI have been considering that will perhaps thematically address many of the points that have been made this morning. What I'd like to do maybe at the outset also is just to update you all on what's been happening here in terms of the Irish legislation. So as many of you will be aware, our government published a general scheme in January of this year, following consultation early in 2019, and indeed, as Joan rightly pointed out, we having had an election during February, we're still waiting the formation of a new government. We're hopeful that that will be very soon, and I think in terms of a draft programme of government for government that's been under discussion, the good news has been that the broad general scheme that was published in January will largely, we're hoping will largely be applied by a new coalition government. And our department indeed has been working on the detail of that legislation, which hopefully, some of which we hope will be released very, very soon. So that's the current situation. No absolute certainty, but certainly all moving in the right direction. A little bit like Ofcom, for those of you who don't know, a little bit like Ofcom in the UK, the transposition of the AVMS is taking place in the context of a wider scheme for the regulation of online harms for Irish residents. So that's been very much situated in that. At the time our government consulted last year, we prepared and submitted within a very short time frame quite an extensive submission, we believe, for the way in which the directive might be given practical effect within the legislative proposal. And indeed, I think many of our suggestions and proposals were actually seem to have been taken on board within the general scheme, and we hope that will continue to be the case. And really, I suppose what that will mean in practice is that the Irish regulator, there will be a new media commission. The BAI, the current regulator, will be absorbed into a new media commission that will have responsibility for all aspects of the directive and for the wider scheme of online harms. How that's looking, I suppose, is that quite a level of discretion will be left. The scheme is one more of broad principles and more general approaches, but a lot of the detail of the regulations that will apply will be left to the future media commission. And I suppose part of the reason that we articulated such an approach was precisely because of some of the complexities which we've heard about this morning. And we ourselves have been working behind the scenes at a lot of the detail in terms of how some of those complexities can be addressed. And of course, we've been cooperating with our European colleagues through ERGA also in relation to that. And I might come back to cooperation just again in a moment. But I suppose the best way to describe the scheme that the BAI has proposed is one of a very macro approach. And it really recognises and is designed to address the issues of scale that we are clearly dealing with in the regulation of video sharing platforms. And I suppose we've articulated it, for those of you who have read it, you'll have seen that we've articulated quite a detailed compliance framework within which we see video sharing platforms being transparent in their systems and in their processes that are applied and in the measures that they will adopt pursuant to the requirements of the directive. And ultimately, that system also has to make them accountable for their actions and their performance against the measures that they adopt. And as I said, this is detailed in much greater detail within our submission. We also point out, and just to be clear as well, I think one of the things we point out in our submission is that Ireland isn't a super regulator for everything that happens on platforms. We've heard some comments this morning around disinformation, for example, concerns about COVID. Of course, we've been very involved ourselves in some of those debates and indeed in work related to that. But just to bear in mind that I think we need to focus in the first instance really in relation to the transposition of the directive itself. I think, as I said, our focus will be very much on making the VSPs both transparent in the measures that they take in pursuing the objectives of the directive, and also to hold them to account at every step of that regulatory process. I'm happy to take more specific questions, but I just wanted to outline and give you some sense of what the what the current situation is here, and hopefully, as I said, I think it's looking good that progress will be made. Obviously, a new commission, many decisions can't be taken in advance of a new commission being in place. But at the moment, we are focusing some of our more detailed work in relation to looking at, for example, the structure of a VSP code might look like. We're also, I think it's important to say that we're also pursuing a lot of work with our European colleagues through ERGA in relation to cooperation and how that might be given effect in a much more comprehensive way, not just at an end stage of enforcement, but also at every stage of the regulatory process. So that, for example, some of the concerns under COO might be dealt with, for example, through more extensive consultation with other regulators, allowing those as an important set of stakeholders to really give a meaningful effect. I think there would be great value in really cooperating, not just cooperating, but as I said, consultation, extensive consultation with other regulators as well. So that continues to be another major plank in our work and in our approach. And I think taking the comments that were made about the Irish Data Protection Commission, which, by the way, and I'm not a spokesperson for the Irish Data Protection Commission, but I think we all know that some of the statements that were made were strongly refuted by Helen Dixon. But just to say that I think it is also a time not just for cooperation between regulators, but for a degree of solidarity, I think, as well, in terms of pursuing the objectives of the regulation and ensuring that it can be done in as comprehensive a way as possible. But recognizing, I think, as always, I think it is about understanding and having reasonable expectations about what's involved here. The regulatory role envisaged under the directive is necessarily a macro role, and I think that should be where that focus is. It should be on that, at that macro level of the regulatory design and implementation. And I think it's important that we don't get overly involved or overly focused on some of that sort of granularity in detail, but that we stick with looking at introducing a macro scheme which ensures that we can deliver on the obligations of the directive, and indeed ensure that the VSP deliver on their obligations pursuant to the directive. I'll just leave it at that. Thank you.
Great, thanks so much. Really appreciate your intervention. So we still have about 21 minutes for discussion. There are at least 3 questions addressed to our speakers, but before we go to the questions, I also understand that Sabine wanted to react quickly to Ben's presentation. So Sabine, go ahead.
Thank you. Just actually one point, I think it's important to clarify. Ben mentioned that automatic takedown, what actually happening in our cases. So what I was referring to is automatic flagging, which does not equally per se automatic takedown. I think it's very important to be very precise here and make the distinction. What we have, especially if freedom of expression is one of the parameters that the content has to be vetted against as well. One other thing I just want to add to is the authority and oversight bodies. Just because Ben mentioned NetCG, I mean, there you have an oversight body and an authority who can strike against systematic failure and can also fine companies, as mentioned, if they feel that the transparency obligations which are laid down in the NetCG are not met. And nevertheless, I think it's fair to say that the transparency reports on NetCG also vary among or in between the companies, which is very logical because the setup of the companies and how they approach certain evaluation actually varies. So I think while you can prescribe very precisely what you want to see in transparency reports, I think it's very needed also to have some more flexibility for the companies to actually deliver the information that is out there, depending on the way the platforms are actually operated. Actually, would like to also make another comment on Celine's commenting and say that I believe that the coordination between the regulators are actually very important, because what I have said in my opening remarks is what we fear as fragmentation actually happening, and this is why I mentioned the 2 German examples, but I'm sure we would find other examples in current fragmentation processes and national laws. What would happen in the end is that on the one hand, we have the platforms and the platform providers who have the country of origin, in our case it's Ireland, but you also have the content providers on the platforms, where you have then different authorities across Europe being responsible. So if the different legislative proposals vary a great deal, what will happen in the end is that tools which we offer to creators or need to offer to creators would vary. And I think this is neither wanted nor useful it's not useful for creators, and it's not useful for end users either. So I think it's so important that we come together, coordinate on what is actually needed and wanted as a setup to avoid this fragmentation, because in the long run, it's actually European users who would be harmed if that fragmentation would take place in the end. So these are just my 2 comments from the interventions done before. Thank you.
Great, thanks so much. So now we'll go to the questions from the chat. So we have a couple of questions to Joanne. The first one is from Victor. What would be a solution to the issue of content sharing platforms and law enforcement not being able to keep up with evaluating and taking down the terrorist content? And the second one from Louis. Can you elaborate on what you see as potential conflict between future German and Irish online arms regimes? I see that they are in conflict on question of jurisdiction, but they are in conflict in substantive obligations placed on platforms. Would it not be likely that the Irish regulator sets minimum processes that must be in place, which would not prohibit German enforcement action against platforms that fail to meet the 24-hour deadline? So Joanne, go ahead, please.
Thank you very much. These are very complex questions, I have to say. First of all, as a matter of clarification, I didn't want to, express any opinion or talk about, the position of each platform with regards to the country of origin principle. What I only meant to say is that platforms, apply the principle of country of origin, or they accept the principle of country of origin in some cases, but in other cases, they of course declare that on the other hand, they respect national legislation. So they also accept that the country of origin, depending on national legislation, will have some exceptions, so to speak. When it comes to the first question, here we need to take into account that regarding terrorism, there's something called the terrorist hashtag database, which is something that is managed under the umbrella of something called the Global Internet Forum on Counterterrorism, which basically means that there's a database based on hashes that when something is to be uploaded that has already been hashed as terrorist content, it automatically goes down even without, any user being able to see it. So this is something that is already in place and is often neglected, assuming that, terrorists are free to do whatever they want or to post any sort of content. In fact, there are already in place mechanisms like this one that are very complicated and very, very controversial when it comes to the right to freedom of expression, because this means that, automatically the content is automatically taken down with the use of just an automated filter that doesn't consider or take into account things as important as context, as the person who posted it, the intention of the person who posted it, etc., etc. So I think that this has proven to be quite controversial because, for example, YouTube deleted. This is a case that has been reported a lot. The archive, the videos of something called the Syrian Archive, which is a collection of videos that showed very serious human rights violations in Syria because they were labeled by this hashtag database as terrorists. So I think that here we have a problem not only from the point of view of the rights of the persons who posted the video, because they might be aware of not that it has been taken down, so to speak, but also the rights of other users that one way or another have an interest in the video being uploaded. But in any case, the problem now that we have with the proposal of a regulation on terrorist content online is that this regulation puts in the hands of the respective national authorities the capacity to decide what is at some point incitement to terrorism. And we can imagine that the interpretation that the Hungarian authorities will probably differ from the interpretation of, let's say, Swedish authorities. I think that this is an important thing. And what is important now is that proper safeguards are introduced here. For example, the need to allow for, let's say, judicial supervision, for example, or that the order comes from a judicial authority. Because we already have, as I said, additional mechanisms that are now at this moment are used to deal with terrorist content. With regards to the possible overlap between the German and the Irish let's say, jurisdiction, I think that the problem here is not only about geography, but also about the different kinds of regulations, because here we may have Ireland applying the Audiovisual Media Services Directive, and Germany applying the NetzDG, or the UK applying the online harms future legislation. Here we are talking about different kinds of regulations. One is more specific, video sharing platforms regulations applied by Ireland, but then we have, let's say, much broader regulations applicable to any sort of online content that can be applied within the context of national legislation, particularly by criminal judges. So I think that what is important now in the context of the DSA, for example, is to find a way that these different possible areas for intervention are applied in a way that is consistent. And this is the role for an European norm, I would say. So it's not that this conflict is unavoidable, but if legislation in the different sectors is adopted and implemented in a separate way, then we may have.
Great, thank you so much. We will continue with a question to Ben, also from Louis. Do you think that the sort of data verification regime you propose is possible under the current data protection laws, or would GDPR have to be amended?
So I think it's definitely possible under the existing data protection laws. And keep in mind that an auditing process does not mean availability for every piece of content. I think such a verification regime does not need to create a surveillance regime, let alone a government surveillance regime that provides any kind of auditor this type of access. What I think is necessary is there needs to be a plausibilization check and also a procedural check in an auditing process that goes beyond what you get right now in the German regulator. What the German regulator's NetzDG regulator is doing is for that process not sufficient because they simply don't have that kind of access. And this doesn't necessarily have to be organized purely by a public regulator. It could also be done by a private sector auditor. There are different ways of organizing this and structuring this. I think the main point that I'm trying to make here, and I think it's quite important, is that when we are talking about issues of online content, we are relying entirely on transparency reports that have not been checked. So again, to come to the example of financial services, in financial services, it's the normalest thing in the world that we ask that there is an audit that takes place of the balance sheet of a company before it is published. And without the auditing of that balance sheet, nobody would take the balance sheet seriously. It wouldn't be a relevant document that we would discuss. So given the importance of these topics, both societally and more broadly, I think that would be highly relevant and highly useful. And just briefly to respond to Sabina's point as well on automated takedown versus automated flagging. I think it's a very good point. And of course, quoting her, she was entirely talking about automated flagging. I think the challenge that we face and that I've seen in a lot of my research is that there's frequently a lot of automation that takes place in a way where the automation, when it includes a human in the loop, this human does not typically have the full degree of agency to respond to the flags in such a systematic way as to ensure that they're able to make all kinds of decisions. So in the worst case, what I've seen quite frequently in many cases is that you have an automated process which flags something, and then later you'll have a human agent which will rubber stamp the decisions of the algorithm. Now, of course, I haven't looked internally at YouTube's data, so I couldn't possibly say that. But I think we need to be careful that when we're talking about 90% flagging in an automated system, this may very quickly become also a similar rate of takedown, which is precisely why it's so important that we're auditing these systems and we're ensuring that the automated system is indeed designed in a way where the human operator has all possible responses and all possible choices that can be made based on these flags, and isn't just saying, ah, yeah, the algorithm is correct, therefore I will just agree with it. To provide one concrete example from this, it's slightly outside of content moderation, but there was a case where automation was used by a Polish regulator to make decisions in regard to social protection systems there. And there, the human operators only disagreed with the automated system in, I think, 1 out of 1,000 cases. So this gives you an idea of when you're implementing automated systems, what pressures are very quickly created on human operators to agree with those systems. And there's a lot of reasons for that I can't go into now into detail. But just to say that there's a close linkage there, which requires, as exactly as Sabina mentions, a careful and precise introspection to ensure that we're actually talking about the same things, and that to make sure that they are effectively regulated in a way that ensures both freedom of expression is upheld and respected and other international human rights, and at the same time that we make sure that content that is identified is then also taken down in a way that ensures that there's a human decision being made and not just an automated one.
Great. I also see that Sabine would like to comment, but before we go to her, I saw that Christina raised her virtual hand, so maybe let's first go with Christina and then Sabine.
Thank you so much. I've received a few private comments and questions, which I tried to reflect now towards the speakers and the reflections we have received so far. So Sabine at some point mentioned the danger, the threat of fragmentation. I think it's even worse, because what we see right now, whether we look at the NetzDG or we look at the French concept, which was published last year and which was very open about abandoning the country of origin principle, very transparently, directly. Also, we see the wake of several national kind of solutions, basically bypassing, overstepping, or contradicting a European type of regulation. So what I see is much more about a competition, or if you would like, a battle of regulations and national responses, and the fight for sovereignty about the online space. And again, what was my, I hope was my main point of argument, is the responsibility question here, to find a solution which keeps at least the principle and the values of European type of solutions. And here, therefore, I'm also turning to Lubos and trying to ask about any ideas, what Ben mentioned and what the two of you published about the data the role and the importance of data verification, and whether ERGA has any kind of plans to to move into this direction, to put forward guidance for national regulators, even maybe to put forward a European type of system that regulators could rely upon. So that would be one of my questions. The other one is kind of a reflection to Celine, I definitely did not want to hurt Ireland in any sense, but the Irish example I put forward is, I think, a warning sign about the responsibility the Irish regulator in the media, if it's the new one, will be faced with. Definitely, Celine, I don't want to be sitting in your chair in the upcoming year, so to say, but I would definitely be happy about an answer what this macro approach, for example, means if we talk about, let's just take the example of hate speech. So how is it going to look like for a European-wide of regulation with a macro approach with regards to hate speech? So what is going to happen with the Holocaust Lüge, for example, within this macro approach? And the last question here is to Mark and about the guidance Ofcom is about to put forward. And I know, Mark, from your previous writings that you were a very great advocate for procedural accountability measures in terms of regulatory approaches. Is the Ofcom guidance based on your concept, or is it similar to that? So yeah, I think these would be my questions, also reflecting on the comments I've received. And the last one to Sabine, takedowns, I think for human rights lawyers especially, definitely for me, are very bad news, because we don't know what is happening with what is being taken down. And other than you, other than the platforms, no one really knows why they have been taken down. And being happy about the removal rates, the removal speed, maybe politicians could be happy about that, but I don't think we should be happy about that. Thank you, that was all.
Great, thank you very much, Christina. We have roughly 2 more minutes. So we proceed first to Sabine. Then if Celine wants to react also to that question. I'm not so sure if Mark is still with us. I understood previously that he had to go around 12 o'clock, but if he's still here, he can also react. And then Lubos, there was also a question to you, and also I think you want to say a few words at the end. So let's proceed first to Sabine.
Thank you. Actually, I think I can combine the answers and comments. I think one important addition I wanted to make is that we don't offer only flagging and removal processes, but also there are appeals processes. So whenever one removal has taken place, and it doesn't matter if it's on a policy violation or a legal violation, the content owner is automatically informed about the removal and has the possibility to appeal. So only in the last quarter of last year, we received more than 100,000 appeals, and 1/4 of these appeals have actually been reinstated. So it's not just about takedown and automatic flagging, but I think it's the whole system that is important to look at. And by the way, it's also something I believe the AVMSD is asking platforms to install. So I think to Christina's point, I think we are also not happy for that we are put in the shoes of the judges in the end. We would hope that actually judges or legal prosecutors or media authorities would report back on content they actually have evaluated and came to a decision on. We found that in reality, it would actually take too long for content to stay on. So it's in the end, at least de facto, our obligation to not leave illegal content being on the platform, but to remove the content. But one of the requests we actually put 2 words and forward to the German regulator is, if they force us to hand our data to the federal police agency, and the federal police agency or the public prosecutors don't believe that the content is actually illegal, we should be informed about this. The same is true also for the Federal Office of Justice. If they get complaints from users that we took down content wrongfully or we didn't take down content wrongfully, they should inform us. So I think after AVMSD, also the regulator, there should be like a back channel to the platforms if the authority finds that content is wrongfully taken down or rightfully taken down. So I think this is very important that both sides talk to each other. So this basically my 2 points in addition to what Ben was saying. So there's not just takedown, but appeals process, and it's being used. And Christina, happy for you to lobby with every government in the world that we are not put in the shoes of the judges in the end. Good luck.
Thank you very much, Sabine. And let's go now to Celine if she wants to respond to Christina's question.
Thank you. So, Christine, if I understand, by the way, no offence taken on the Data Protection Commissioner. I was just noting that the fact that she had a different point of view. So, in relation to something like hate speech, I think your question was really about where cooperation, for example, might sort of address some of these concerns. So I think I suppose that the first piece really will be looking at that potential for the development of a code or guidance for VSPs. The draft legislation envisages that there could be quite a range of codes that would support the achievement of the legislative objectives. And I think within that, I think that consultation in relation to a code. So for example, things like elaborating a definition and the type of way in which perhaps local or national specificities might apply are all things that could potentially be considered in terms of guidance within a code as well. So I think there is the potential, I suppose, for other regulators to input into how that might be achieved through a VSP code. And I think that's where that kind of consultation and cooperation might help to achieve some of those more, if you like, local or national objectives on specific issues. But that will be a process that, I think will require real engagement by different regulators. And some of these issues obviously have not been discussed as yet, but I think we would certainly envision that level of extensive cooperation that might be able to give account or allow a VSP to take account, for example, of national specificities. That might be something which would be within the scope of a code. And I think those are some of the ideas, as I said, that we would be exploring. And I think that cooperation at this level of detail, when we get down to looking at some of the specifics, for example, around hate speech, it's one that we've considered very closely, knowing where there are very significant and serious sensitivities in different parts of Europe. I think those would be some of the options that we would be certainly very open and very willing to explore through our cooperation mechanisms.
Thank you very much, Celine. And I will give the floor now to Lubos.
We wanted to give floor to Mark, I think, and I still see him. So if he wants to intervene,
I haven't seen him. I haven't seen him. He's here. Okay.
I am still here. Yeah, thank you. But I'll be very brief. Thanks, Lubos. On the question, I very much agree with Celine's points about codes and the scope for cooperation on codes. On the question about what guidance might include, clearly we're still early in our process of developing policy, so I haven't got too many specific details to share. But I think what I would say is that we would anticipate providing guidance both on the application of the measures prescribed in the directive, based on evidence that we gather about their effectiveness in different circumstances and with respect to different types of content. But also, we would expect to communicate expectations about the governance standards and the accountability standards that we would expect platforms to meet. So that might include, for example, guidance on clarity about terms and conditions, excuse me, clarity about what measures of success platforms have in place, standards about disclosure, both to the regulator and via transparency reports to wider stakeholders, and guidance about the role of consultation with stakeholders in the development of platform policies. Although we haven't worked through those specifics yet, I think it's important to have a distinction, but also to include both guidance on technical systems and standards, but also those broader governance issues that I've described.
Great, thank you, Mark, and apologies for not seeing you before. I didn't mean to bypass you. So now I will give the floor to Lubos.
Thank you very much, and I'm very conscious that we are already over time. So very briefly, thank you all for coming here, because I think this is a really important debate. This is only a partial kind of thing about content moderation and video on the platform, but I think this will show a way for the future. If it's successful, it will unroll probably to other areas. If it's not successful, we have a big problem. So I think let's continue debating this, and we've seen that there are developments going on in Ireland, in other countries. Of course, will be very interesting to follow on this. So I think let's probably continue the debate, and we can meet again in a few weeks' time to see what's happening. I think it's been mentioned many aspects, not all of them, but we've mentioned many aspects that are coming into it. I would just mention a few of them. The cooperation, extremely important now, and Celine knows this very well. Of course, she's partly in charge of this work stream within ERGA. I know how we can complement each other in this, because Ireland will be the regulator, will have the jurisdiction. But if the others are not helping, I think we will not see any potential beneficial development. So everybody needs to put the work into it. It's also we're seeing the complexities in jurisdiction, but the complexities are not even between the NSDG and the AVMSD, but are even within AVMSD itself. And Sabine already alluded to that. But we now have Ireland will have a jurisdiction over VSP as such, of the platform like YouTube, for example. But there are channels within YouTube that will be governed and regulated by different countries. So you have a service within a service, and those services are under different jurisdictions. So to really avoid potential clashes, or at least somehow accommodate both of these aspects, it will be extremely difficult, and without cooperation between regulators, it's just not possible. So this is a really important aspect. The country of origin principle, indeed, Christina said that there are attacks on that, and big countries can live without country of origin principle. The small ones just can't, because they will not be in position to protect themselves or to establish rules that will actually help them in the digital environment. So I think for smaller countries, it's absolutely crucial the country of origin is still there. And again, back to cooperation, this can be only done with proving that cooperation actually works, and that can prove that country of origin principle can survive this. And transparency, of course, I think AVMSD is helping with transparency in content moderation. But as I said, and as Ben was stressing very well during our talks, is that the verification is extremely important. Now there's a new development here. It's a new institution called EDMO, European Digital Media Observatory, that started to work from 1st June, and there's a lot of hopes in Brussels that this might help with the thing. What we said before with Ben is that there need to be probably one institution that can do the checking of the data and then provide the data to other institutions, like regulators, but also others. That not everybody, it won't be helpful if everybody can see and verify the data for themselves, but we need some kind of system to do that, because the meaningful transparency means that we actually can verify what data we're getting, and it's the only way to get to accountability. And we can't stress enough, I think, how transparency is important, because every solution that we are now seeking starts with transparency. Without knowing what's happening, you can't have a meaningful regulation and meaningful rules in place. So everything, whether we're talking about disinformation or we're talking about protection of minors, start with understanding the problem, and understanding the problem is only we can be able to do that only with meaningful transparency. So this is probably my kind of try for wrap up, but you know it's extremely difficult. I think let's continue with this debate. I think it would be just I will be very happy to see you in a few weeks, months time, just to follow up on what we heard today and to see the developments in countries, because the legislation will be coming in. Over to you, Rastya.
Thank you so much, Luboš, for this great summary of what has been really a very exciting discussion. So first of all, I would like to thank to our speakers. I would also very much like to thank to our participants. Apologies for running a little bit later, I mean, than initially anticipated. As for what we are planning to do next, we will definitely prepare a report. And for those of you who joined a little bit later, in terms of ability to get a link or recording, this will be the subject of approval by the speakers. But with this, again, thank you so much for being with us, and hopefully you will have the rest of the productive day. All the best.
Thank you. Bye.
Thank you.
Thank you.
Thanks. Bye-bye.
Bye.
Thank you. Bye.
Bye-bye. Bye-bye.
Ale nie można z nim pracować, to będą mogli połączyć.